All right, good morning, everyone. We'll get started. My name is Xochitl Leon, and I'm the chair of the California Board of Accountancy's Enforcement Program Oversight Committee, and I'd like to call our meeting to order. Let's start by taking roll call. If we may start over here with Ms. Wright.
Kathleen Wright.
Katrina Salazar.
Alicia Burhow.
Excellent. I think we have quorum. So moving on to our agenda items. Number 1, approval of the minutes for November 17, 2016. Do I have a motion to approve the meeting minutes for November 17?
So moved.
Second.
Any comments from the rest of the board? Any comments from the public? I think we have a motion. Motion carries. Oh. If we may do a roll call?
Alicia Burhow,
Yes.
Kathleen Wright,
Yes.
Katrina Salazar,
Yes.
and Xochitl Leon.
Yes. All right. The motion carries. Thank you. Moving on to agenda item number 2, the proposed timeline for making changes associated with the disciplinary guidelines and rehabilitation criteria. Mr. Franzella, please begin with your presentation.
Thank you. Good morning. So over much of last year, the CBA has considered various amendments to its disciplinary guidelines. So in an effort to keep the CBA informed regarding the overall progress and expectations for the revision process, staff developed an initial revision schedule. And as the CBA has made progress on the guidelines and rehabilitation criteria, staff have updated the schedule for each of the meetings. The most current version of the schedule can be found beginning on the bottom of page 1 of your materials and continuing on through pages 2 and 3. As noted on the bottom of page 2, for this meeting, the CBA will be continuing its discussion regarding a modification to the minimum penalty for violations of Business and Professions Code Section 5100A. If at this meeting later today the CBA were to initiate the rulemaking process, staff anticipate that a public hearing on the regulations would take place at either the July or September 2017 meeting. There is no specific CBA action required for this item, and staff have no recommendation for the item. So I would like to now turn the discussion back over to Chair, and I'd be happy to answer any questions members may have.
Any comments? Okay. Seeing none, let's move on to agenda number 3. Agenda number 3 will be having a discussion and possible action to initiate a rulemaking to amend the disciplinary guidelines and model orders and CBA regulations, section 99.1, rehabilitation criteria. Mr. Franzella?
Thank you. So for this item, the CBA is being asked to review the proposed changes to the regulations and possibly direct staff to initiate the rulemaking process. This committee has been considering various changes to the guidelines and criteria since March of last year. On the bottom of page 1 and top of page 2, staff have outlined the various modifications the CBA has considered. The only remaining item at this time is for continued consideration related to a possible reduction in the minimum penalty for violations of Business and Professions Code, Section 5100A. Based on a recommendation by the CPC, I believe it was at its September meeting last year, the CBA assigned the EPOC the review of a reduction in the minimum penalty for violations of Section 5100A, which are conviction of a crime substantially related to the qualifications, functions, and duties of a CPA. The CPC had recommended that the EPOC consider a reduction to the minimum penalty from revocation stayed, actual suspension of 120 days and 3 years probation, to a suspension stayed and 1 year probation. So at its November meeting, the EPOC considered such a reduction, and during its discussion on this topic, the EPOC heard from counsel regarding various concerns related to reducing the minimum penalty associated with these types of violations, including the ability to timely file a petition to revoke probation, the need to ensure the CB articulates the advancement of a public policy being achieved by any reduction, and that administrative law judges generally gravitated towards the minimum penalty. So, as the EPOC considers the changes, as the EPOC considered those changes, members noted that the initial discussion on possible reduction arose from the CBA's discussion on criminal convictions arising from drugs and alcohol, and therefore the EPOC ultimately moved to table the item and to consider it at this meeting a possible reduction to Section 5100A that was had a more narrow or limited scope, focused on convictions specifically related to drugs and alcohol. So as requested by the EPOC, staff have revised the guidelines to narrow this reduction and to more tailor it to violations involving drugs and alcohol, thereby leaving the prior minimum penalty unchanged for all other types and natures of convictions. So the revised text for the minimum penalty we did include in the guidelines in attachment 1, but for ease of review, staff have included an excerpt of the language on page 4 of the actual agenda item. So in developing this more kind of narrowed approach, staff focused on drug and alcohol convictions that are more common with respect to actions taken by the CBA, which are primarily DUIs and drug possession. So for DUI, staff have included in the new language a reference to Vehicle Code Section 23152, which staff did provide the full text in attachment 4. And this Vehicle Code section covers DUIs for alcohol-related matters and drug-related matters. As for crafting the specific language related to drug possession, staff looked to Proposition 47, which was passed by voters back in 2014. We've included attachment 5 to the item, the official title and summary that was prepared by the Attorney General as related to Prop 47. Now, Prop 47 sought to reduce the penalties for certain offenders convicted of non-serious or non-violent property and drug crimes. So, for drug possession, as it noted in Prop 47, focused on possession for personal use. Therefore, staff used this terminology for revising the language associated with the reduction in penalty for violations of Section 5100A. When we were preparing the language, to more narrow that focus, we needed to kind of bifurcate various violations for 5100A for basically all other convictions and those that are specific to drug and alcohol. So the first part of the language that you see on page 4 maintains the existing penalty for criminal convictions except those instances of convictions of misdemeanor DUIs and drug convictions for personal use. The second part of the language is where members will see the reduced penalty, which focuses on misdemeanor DUIs and drug possession for personal use. Staff have prepared amendments to the necessary regulatory sections, which include CBA Regulations Section 98 and 99.1, to provide the CBA the ability to initiate a rulemaking to amend the guidelines and the rehabilitation criteria. The guidelines themselves are all of attachment 1 with strike through and underline. Section 98 has the strike through and underline related to the incorporation by reference of the guidelines, and Section 99.1 includes the appropriate strike through and underline, and these can be found in attachments 1, 2, and 3 of your materials. So if the CBA supports the regulatory changes being proposed, staff recommend the following motion to initiate the rulemaking, which members can find on page 4 of your item. Specifically, the CBA approve the regulatory text in the guidelines and CBA Regulation Section 98 and 99.1. Direct staff to submit the text to the Director of the Department of Consumer Affairs and Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all necessary steps to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing. So at this point, I would like to turn discussion back over to the chair, and I'd be happy to answer any questions members may have.
Any discussion from the committee? Yes, Ms. Wright?
Thank you. Dominic, what confused me when I read this was reference in the attachments to number 5, Proposition 47, which still indicates on page 36 of that proposition discussion that marijuana is either a infraction or a misdemeanor, which has been now essentially deleted or updated with Proposition 64, which would hold that it no longer is a misdemeanor. Possession, at least, within limited quantities, and then in January of 18 is when the recreational sale becomes legal, so to speak. Can we fix that somehow?
All we're trying to use Proposition 44 was a terminology.
47?
Sorry, 47 was terminology, not to reference any specific sections or crimes that are outlined in 47. It was really looking at a way to develop a terminology that was well used and well understood related to drug crimes and for personal possession and personal use. So personal use drug crimes, and that's what we used 47 to draw from, not to concern ourselves with the recent passage of Prop 64 or anything else in 47. So it's just really to help the board have a place to point as part of its rulemaking package to understand why we're using certain terminology.
So this regulation would allow us the flexibility to accommodate the current state of the law in California.
Yeah,
regarding
if you're not-
possession of marijuana. I mean, we shouldn't see it,
Yeah,
actually.
if it's not a conviction of a crime,
Yeah.
which 64 kind of addresses, then it wouldn't be an issue for us.
Yes.
So one of the things we have to do when we're drafting a rulemaking package for review by the director, agency, and the Office of Administrative Law is to explain the policy reasons behind the necessity for the change. And so essentially what the staff have done, if they've done research and shown that currently under propositions and recent amendments to the Constitution, that the public policy of the state regarding some crimes for personal use has changed. And I think that it was just a basis for a kind of an illustration for how public policy is changing in this area, and that was one of the reasons for why the board was seeking to lower the penalty with respect to personal use crimes. I don't think they were trying to analyze Prop 47 and its legal effect. I think they were just trying to reflect the public policy of the state and as a basis for the change because we have to justify the necessity for the change to these regulatory control agencies. They put that in the packet so we could have that discussion.
Okay, and a discussion which I think we do need to have, which is not on the agenda for this meeting, is whether or not federal would actually enforce their statute, commence the enforcement of their statute regarding the same topic. And then what would we do with it if we got an infraction under federal law, which was actually illegal activity under state law?
I think the current proposal that you have would cover all types of personal use crimes, whether it's federal or state, and it simply is a reflection of this board's policy potentially, because you haven't voted on it, regarding how you would begin your analysis of how long it would take to analyze whether someone is rehabilitated. Because when you set your minimum probationary periods, what you're saying is this is the minimum amount of time we need to determine whether someone's rehabilitated for this type of crime. So I don't think what the staff have in front of you would in any way not be flexible enough to accommodate the different types of convictions you could see.
Ms. Alicia?
Yeah, I just had one quick question. So in relation to what you said, Ms. Wright, in when we have recreational marijuana that will be allowed for sale, I guess, in 2018, do we need to revisit this then or adjust this if we were to go ahead and approve this today? Or, I mean, we haven't set a motion yet, but if we were and we approved it, would we have to come back in 2018 to adjust for the
No.
2018? Okay.
No, that's what I was saying. I think, once again, it would be whether you agree with this policy change. If you did, it's flexible enough where if you think something's more serious based on the facts of the case, you could have a higher probationary period. But what you're saying is 1 year is enough to start with most of these types of personal use possession crimes.
Okay. All right. Thank you.
Any additional comments? Do we have a motion?
Make the motion. sorry.
Because you have to restate it, don't you?
I am going to restate,
Thank
believe me.
you.
So I would recommend that the CBA support a reduction in the minimal penalty associated with violations of BBC Section 5100A for convictions related to drugs and alcohol, that staff, and additionally, staff, to recommend to staff that the CBA make approve the regulatory text in the guidelines and CBA regulations sections 98 and 99.1, to direct staff to submit the text to the Director of Department of Consumer Affairs and the Business, Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, making any substantive changes to the package and set the matter for hearing.
Do we have a second?
Second.
Are there any public comments?
I did want to ask one more question.
Mm-hmm.
So I just want to make sure, because I was kind of restating the staff's recommendation. So the reason why you're changing it from 3 years to 1 year, can anyone articulate the policy why you're changing it from 3 to 1? Do you agree with the staff's Prop 47 analysis, or do you have other rationales for why you think the 3 to 1 year is a good idea? We only need this because we have to write this paper up for the agencies.
Well,
Go
I agree
ahead.
with the Prop 47 thing, I agree with the staff analysis on Prop 47. I
Okay.
mean, that's the primary issue. I mean,
Okay.
personal issues, if, in terms of, as we've discussed this over the last couple of years, if we see that drug and alcohol possession or DUIs in this particular case are not affecting the practice of accountancy, then I don't see why we can't be going and adjusting the rules as they are. Does that make sense?
So you're saying that you think that 1 year is a sufficient time to determine if additional protections need to be put in place for a particular licensee if they have this type of conviction?
Yes.
Chrissy,
Okay.
my general sense in the limited time I've been on the board and listening to these discussions is that these particular types of offenses were less related to the practice of accounting than, for example, theft, fraud, embezzlement, and things of that nature. And not irrelevant, but less
Right.
directly related.
Correct.
And therefore, in the consideration, based on the facts, obviously, that a lesser assigning a lesser penalty, or allowing us the flexibility to assign a lesser penalty, is what we were asking for.
Okay. I think, it's hard for people to get the idea that the case law does indicate there is a relationship. When you don't see it actually happening, the DUI doesn't happen exactly on the job.
Correct.
The issue is whether that person is safe to practice.
Mhm.
And so there is case law and authority for the proposition that it's related. The only question then is how much time do you need to evaluate based on this type of crime, whether they're a risk still or whether they're rehabilitated. And so I think that legally it's acceptable if you believe in your experience that 1 year is enough time to determine whether someone would relapse or have other issues, then that's a legally defensible position to take to reduce the penalty. So the only question I had was, do you think that it is enough time?
It's my best recollection, and this is not my area of practice, but that these cases involve the medical practice.
No, there's cases
Are there
involving
cases on
attorneys.
accountants?
Attorneys.
Attorneys, but not accountants.
We have had multiple cases where we've imposed license discipline before it happened on the job, and then the person ended up admitting at a petition hearing that they did have an alcohol abuse problem and that this was a wake-up call for them. And so we have multiple cases where the discipline was imposed for a competency issue, because alcohol does affect competency. But the cases that I was talking about at the Supreme Court level are healing arts board cases and attorney practitioner cases. And the courts don't see a distinction based upon the type of practice that you're in.
So, going back to her question, I think.
Okay.
For me, yes.
Okay, thank you.
I feel that 1-year probation is sufficient.
Sufficient, okay.
And I would just add into that, we have a whole toolkit of biomedical testing and ways to follow up, and so a year, I would concur, especially if we're, again, depending on the severity of the case, requiring the frequency. I mean, we can gather a great deal of data within a year regarding usage through testing if needed.
Okay, thank you.
Yes.
And just, I would also like to remind the members that the proposed amendment is to a guideline, and that does not prohibit board staff, when appropriate on a case-by-case basis, to make adjustments during negotiations of settlements, nor would it prevent the board to make adjustments to any decision that comes before it that it believes on a case-by-case basis warrants more severe action.
Okay, so any public comment? Can we call for a vote?
Katrina Salazar,
Yes.
Soshi Leon,
Yes.
Kathleen Wright,
Yes.
and Alicia Burhow.
Yes.
Okay, so the motion carries. Moving on to item number 4 on the agenda. Any additional or any public comments? Okay, hearing none, moving on to item number 5. Any proposals, discussion for agenda items for the next meeting? All right, well, hearing none, the meeting is adjourned. Thank you.